I picked the first and third virtual juries in California and now have more experience than any other defense attorney I know in virtual trials. This is something never envisioned by our forefathers. It's a completely new frontier. Court rules in the Constitution contain no provisions regarding virtual trials or virtual jury conduct, so they are subject to abuse. I made a motion to videotape the third virtual trial that I was involved in based on lessons learned from the first. Let me give you an example from the third case. What you're going to see is the plaintiff's first witness, who's an expert epidemiologist, opine about whether or not the plaintiff received a significant dose of asbestos exposure from talcum powder. This is his testimony.
Yes, my understanding is that the talcum powder did contain asbestos, or some of it, and others will testify about that. But that's my understanding, based in part on reading in the literature. I'm not expert on it, but nevertheless, my opinions are based on that understanding. So that would mean that he would have inhaled intermittently asbestos from his birth, 66, and I think you said up to 19.
I'm taking little pieces.
Excuse me, I have an objection now. It seems like the witness is reading something. He looked down. Does he have notes or something in front of him? He's looking again.
Well, I was sent this hypothetical, Your Honor, to check it out.
Okay, he's not supposed to have anything in front of him. He shouldn't be reading anything whatsoever. This is completely
I disagree,
improper.
Your Honor. I'm sorry. An expert is allowed to have his file with him in order to review, Your Honor.
He's not allowed to look at anything without permission of the court. Anything at all.
I think the protocol was to not have any documents. So why don't we proceed that way for the next 6 minutes?
The biggest takeaway from virtual trials is to expect the unexpected. Because people are out of your physical presence, they are exposed to things that you can't see and you can't even anticipate. So first, there has to be a series of motions that precludes witnesses from having access to any means of communication during their examination, computers, phones, notes, etc. The screen needs to include not just a talking head, but what's in the witness's presence, his or her hands, the desk. You have to be able to see what they're looking at, what they're writing, and how they're acting, in addition to just hearing the words that they say. If you haven't conducted a virtual trial before, you need to start with the mistrial motions that were made in the virtual trials that occurred in the past. The number of errors, the number of things that were unexpected have largely been documented in motions for mistrial. In addition, you need to make a motion to videotape everything that occurs in the trial, with the exception of any communications or the physical presence of the jurors. Without videotaping, there's no way to have a complete record of what happens. Control is the key to cross-examination. In a courtroom, you can control who the witness is looking at, what they're looking at, and how the jurors perceive the witness by your own motion. In a virtual trial, you can't do that because all you're talking to is a little screen. So you have to plan for that. Instead of letting your opponent set up his witness in the way he wants to or she wants to, you have to have input into where the witness is, how the screenshot is depicted, whether you can see the person's hands, their desk, their movement, and any materials that they're looking at or using. Virtual trials in their entirety are not here to stay, but virtual portions of trials are here to stay. As we continue to try cases, courts will be more liberal in allowing witnesses to testify virtually and not as rigorous in forcing witnesses to come live to trial. So even if the lessons learned from complete virtual trials won't apply to complete trials, they will apply to portions of trials moving forward.